And I think you ended just where Art will probably want to start.
Sure.
So over to you, Art.
Thank you, Charles. And I want to thank Lemma and the organizers of the conference for inviting me to be here today. I think a conference on systemic risk and data is quite timely. As Charles said, I'll talk about the FDIC's role in a post-DoddFrank world and with respect to systemic risk, particularly our participation in the FSOC and our new resolution authority. But before I do that, just want to say when it comes to data, the FDIC is very supportive of the kinds of things that DoddFrank has done to improve the data that's available in the financial system, particularly the OFR and some of the other efforts. You know, the FDIC is the agency that collects the call report data from the insured depository institutions, the banks, every quarter, and makes that available to the public and to analysts and publishes it in our quarterly banking profile every quarter. So we've done a lot of work on that. A few years ago, we had to upgrade that system. It had been very old, and we built a new system along with some of the other agencies, and we incorporated XBRL, built it with that as the base, and we found that was a big gamble for us, I think, and it worked out, and our data is now much more available more quickly to the analysts, and many have taken advantage of that. And so we support all that. I'll just mention one of the things that we're working on, or just starting to work on. You know, in the last banking crisis, I was fortunate or unfortunate to be here for the last banking, the thrift crisis back in the 80s. And one of the things that we didn't really do a good job of, and maybe because we weren't able to, is to keep the data that came out of the failed banks, all the banks and thrifts that failed, and the information that was in there. And back then I happened to work on some of this. We did it by hand, and you know, we still have some of it, but not much. And what we're working on now is to make sure that that doesn't happen again. We have the technology, we have the ability to make sure that we keep that data. Over 350 banks have failed in this crisis, and what we're doing now is working on a pilot where we've had some of our people go into that data from a few of the failed banks, and you may know when a bank fails, we download all the data. This is for filing legal claims, doing our resolution process. So there's a lot of good information in there, and it's not just the sort of database information, but it's also the legal documents, what Andrei was talking about, pulling out of readable documents the information. So we've got a lot of good information there, so we're going to be working on that, and I think that'll be of interest to the research community in the years down the road. So let me talk about the FDIC after Dodd-Frank. As everyone knows, this crisis exposed some gaps, the lack of information on the financial system and some gaps in the regulatory structure, shadow banking and so forth, and particularly institutions that were operating that were not subject to prudential supervision and capital regulation and a resolution regime that banks were. And it's interesting to note that the crisis was preceded by severe problems at three institutions, Bear Stearns, Lehman, and AIG, that were not subject to that type of oversight or resolution authority. And that left policymakers faced, when these firms had troubles, with two bad options: the option to bail them out or the option to let them go into bankruptcy. And policymakers decided to do both. Bear Stearns, they provided some assistance. Lehman, they put into bankruptcy, allowed to go into bankruptcy. AIG, they bailed out. And none of that had positive effects. And so what Dodd-Frank did to address that was to try to fill some of these regulatory gaps by creating FSOC for the kind of collaboration that's been mentioned. And in particular, it gave the FSOC the responsibility for designating SIFIs, systemically important financial institutions. And these are firms that, once designated, will be subject to two new important authorities in Dodd-Frank: heightened prudential standards, which the Fed will administer, and then the orderly liquidation authority that the FDIC has. And so what has the FDIC done with respect to this new authority? We've been participating actively in the FSOC. We described the committees, and he mentioned the annual report. That was a very collaborative process, putting together the annual report. And if you haven't looked at it, I'd recommend it to you. It was the first effort for this group of agencies that had come together, and I think it is a good document, and I think it identified many of the things that are happening. Obviously, there were some things we maybe could have done a better job on. We've also been working on the SIFI designations, and from the FDIC's point of view, the SIFI designation we feel is very important because if a firm is designated as a SIFI, it will be subject to the requirement that it have a living will, a resolution plan. And that's important for us because what we don't want to be the case is that down the road, when an institution gets into trouble and the policymakers decide that it should be not handled through bankruptcy but should be handled through the FDIC's new resolution authority, that we have not have the planning, the resolution plan process for that firm, and that we are handed it at the last minute without the kind of planning that we do for banks. So we feel this SIFI designation process is quite important. We've created a new office in the FDIC, the Office of Complex Financial Institutions, and I'll just describe its organization. It may be something that you want to become familiar with. It has three groups. It has a group that's there to monitor these large financial institutions. It has a group that does the resolution work, the resolution planning, and the actual resolution should one be necessary. And it has a group that works with the international community to address some of the cross-border issues that come up when you try to resolve a financial institution. So let me spend a few minutes talking about what these new resolution authorities are. They're Title I and Title II of the DoddFrank Act. Title II is the orderly liquidation authority that the FDIC now has. And this is very similar to the authority we have with respect to banks. It's something that we can apply a very similar authority to non-banks that are designated as systemically important. And you may or may not appreciate this, but even within a bank holding company, our previous authority was with respect only to the insured depository institution, the bank. It was not with respect to the holding company, nor to the broker-dealer or other affiliates. So when you think about resolving a large, complex banking organization, we didn't really have the kind of control that is necessary to do it in a way that would have been as effective as it needed to be. So Dodd-Frank changed that. We now will have the ability to deal with the entire organization, as well as with firms such as AIG and others that are designated as systemically important, even if they don't have a bank affiliated with them. This new orderly liquidation authority is not a bailout mechanism. This is not like the deposit insurance fund. There is no fund there to provide a guarantee for certain liabilities. This is simply a matter of using a resolution authority to unwind this firm in a more orderly way than would be done through bankruptcy. And one of the things that we need to do here is to make sure that the treatment of creditors is appropriate, that shareholders take losses, and that the creditor stack is treated appropriately so that the more junior tranches take the first losses and so forth. And we also are asked to consider the implications of the resolution on the system, the financial system, and the implications that it would have, and the possibility of creating additional systemic risk or the goal of minimizing systemic risk. And we have done some rulemaking on this. We've done rulemaking on our orderly liquidation authority. We've done rulemaking on what's called the resolution plan, the living will. And so that is out there, and we're now about to start the process of requiring these firms to have living wills, or resolution plans as they're known. And we think it's very important that these resolution plans are taken seriously. These plans are done jointly with the FDIC and the Fed. A firm is required to have a plan that shows how it could be resolved under bankruptcy, not under our authority, under bankruptcy, in a way that would not be disruptive to the financial system. They are required to have these plans and to update them annually and sometimes more frequently. These plans need to be deemed credible by the FDIC and the Federal Reserve. And if they're not, certain changes can be required. There can be additional capital or liquidity requirements placed on it. And if after 2 years it's not found to be credible, then the regulators can require divestiture of certain operations. So if a firm cannot produce a credible plan, the regulators have the authority to require some breaking up of that. So that process is just beginning. I think it's worth paying attention to. We're going to work very closely with the Fed. I think we've had a lot of outreach with the industry on this, and I think they're taking it seriously, so we're optimistic on this. In order to sort of acquaint people with our resolution authority, which many people aren't familiar with, we put out a paper on how the Lehman bankruptcy, the Lehman failure might have been handled under this resolution authority. And I don't know, I'd recommend that you take a look at this. Essentially, we argued that had this authority been in effect when Lehman encountered its problems, that it could have been resolved in a way that would have been less disruptive to the financial system and better for creditors and other stakeholders in the firm. And essentially what we argued is that had this authority been in place, we would have been in the institution earlier, presumably as early, if not earlier, than the spring when Bear was having its trouble. We would have been in there doing what we do when banks are in trouble. We would have been putting pressure on management and the board to raise capital or find an acquirer. And if that had not been successful, we would have then, at some point, held a competitive auction process with some of the parties who had done the due diligence on the firm, and that we think that we would have been able to find an acquirer for Lehman Brothers. There would have been losses imposed on the creditors of the holding company. The shareholders of the holding company would have been wiped out, and creditors of the holding company would have taken losses. But the broker-dealers, both the UK and the US operation under it, would have continued operations. It would have been much less disruptive. And that's the case we make in the paper. Obviously, it's hard to argue the counterfactual, how the world might have unfolded, but I think we're pretty confident that we could have affected a resolution that was far better than what has actually occurred, where it's been over 2 years and still, I believe the creditors have not received any cash. With our authority, we have access to liquidity, and we do what we do. We would plan to do what we do with banks, which is provide liquidity very early on, if not almost immediately. So I think the reaction to the paper was there was some skepticism, but I'd urge you to take a look at it. So let me close by just saying, when you think about what we need to do for this resolution planning and actually carrying out the resolution, the kind of information that we need, when you think about the resolving of large, complex financial institutions, one of the big problems is that the business lines are not organized by legal entities. So there's often very little congruence there. And so that makes it very difficult to unravel one or to resolve one. And so through the resolution plans and through the LEIs, that will be in a much better position someday to address that. And then just understanding the exposures of the firm and understanding when we take these actions and impose losses on certain creditors, who will take losses, what will the subsequent implications of that be? Again, in the fall of 2008, we were making a lot of decisions that without a lot of information, and I think the OFR and their efforts will be very important in putting us in a better position to make good decisions when we have to do one of these resolutions. So with that, I'll stop. Everyone else did it, so I'll put in a plug. We'd like your students and your researchers as well, so come see us.
Well, thank you very much. I think I'd be surprised if the earlier sessions of the conference hadn't had some of the same tenor that you heard from our panelists today, which is that we are embarking upon an historic, broad and profound program which will change the way the financial industry works if it's carried through to fruition. And I think there is a strong commitment, which you will have seen exemplified by our speakers on this panel, to doing that. You can think about the problem in many, many different ways of how do you monitor, measure, and manage systemic risk. And sometimes it's helpful to have a very simple paradigm as a starting point anyway. And I like to think about it in terms of what do you need in the way of information, systems, mandates, regulatory authorities, industry capabilities to help avoid potential areas of high systemic risk during normal times. So how do you think about shepherding the financial system away from potential areas of high risk? So kind of what do you need for normal times? And then what do you need for crises? When things have begun to go south, how do you contain it? How do you incent and manage behaviors that will which will cause the crisis to be less severe than it would have been otherwise? So we're addressing crisis severity and frequency by thinking about it this way. In both areas, I think there are enormous challenges. I had thought for some time that, in fact, monitoring for systemic risk wasn't so tough, that one could do that with fairly low-frequency information. There was a problem of imagination, of trying to figure out what the next crisis might look like, so what should we be monitoring? And there may be areas of data we don't have which we need to get. But so to speak, the technological problem, the scale of the program would not have to be huge to make some strides in terms of thinking through issues of connectivity, size, positive feedback loops, and so forth that might be important to understand better in normal times. I'm not so sure that's true now, because I think we've had in the flash crash a sort of an indicator that we may need something much closer to real time, even when we're monitoring risk. And we may have to think about developments that are kind of unprecedented, where suddenly a new area of activity becomes very profitable, becomes very large, and whereas that might have unfolded in 6 months or 24 months in the past, it might unfold in a very short period of time today and in the future. So we may need quite a lot of capability to monitor risk. We certainly will need it to manage it. So this is an enormous program. I think one of the questions we should have is sort of how, what does the business case look like? Normally when you think about big programs, you want to break them up. So are we breaking them up the right way? Are we breaking this program up the right way? Have we got it phased in that makes sense from a point of view of our priorities for systemic risk management and the return, so to speak, to the financial industry, but also to, of course, society more broadly from each individual step along the way. I think it's also important for us to think about, given what you've heard in this panel, where the gaps may be. So do we have, if we have an overall plan or a program that's implicit here about what we're trying to do, what are there potential gaps that you see that may get neglected, or big issues that may be potentially things that either the regulatory community or the industry should be giving more attention to as this program unfolds? So my request to you is to put your questions to this group of practitioners, people who are engaged in moving this program forward through its initial stages. Your questions and your comments would be welcome. So we have a starter there. Thank you.
Yes, so Alan King, IBM. First of all, I would like to thank the speakers. It seems like remarkable progress is underway, and I'm very glad to see it. I have a question that kind of links back to the earlier session this morning, and we had a conversation at our table about this. The problem is that of the delevering process that's going on in the housing sector right now. And this doesn't amount to a crisis in the sense of there aren't institutions that need to be unwound, but the process of unwinding mortgages is obviously extremely painful, and I know that there are task forces being set up to deal with this. But I'm just wondering, from a regulatory standpoint, is there something new here that needs to be looked at from the perspective of monitoring, incentivizing, and so forth? And the particular example that came up at this table was the lack of incentive in the trustees of these mortgage-backed securities to be proactive in reaching out to investors, particularly in the case of short sale situations where investor opinions need to be reached. Obviously, this process, I have personal experience in this, takes an extremely long time and is really gumming up the works in deleveraging. So perhaps we are seeing a new phenomenon that could lead to crisis, in which you guys would be all called in front of the congressional committees, but it's in its very slow-moving kind of phase. We have a recent experience of a very long-running delevering process in Japan that never seemed to get to crisis stage, which would have invoked any one of you people to come up and do something. I'm just wondering if you have any thoughts on that.
Well, certainly about the systemic health of the financial system. Dick.
I knew I was going to get the fickle finger on this one. So the answer, Alan, to your question is that, part of what's gumming up the works has to do with legal issues that go beyond the scope of what we, I think, on this panel are charged to deal with. But part of it also has to do, with thinking about ways to ungum the process, that we could possibly address. And, from a policy perspective, it's not just the legal process, but it's also providing the right incentives. And so I think that the slowing in economic activity recently, I think, has given renewed attention to the things that we might do as policymakers that go beyond our mandate, the mandate on this podium, to think about the things that affect systemic risk and that may interact with macro policies, to think more broadly about things that might affect housing finance or housing markets that, that could accelerate that process in a way that was constructive, no pun intended. And I think there are several answers. Some of the proposals have already come out. So, for example, if there are imbalances in a physical sense, with the overhang of real estate owned by the various federal agencies, to accelerate the disposition of that real estate owned. Second, to convert ownership into rental in a way that's also constructive. Third is a way to accelerate the process of write-downs with potential for principal reduction and refinancing in a way that balances the need to bring relief, to promote price discovery in housing markets, where those markets are still burdened by uncertainty about where the bottom in prices is going to be in many of the markets. I think taken in isolation, none of those things is likely to produce the desired result, but taken together, since we have a multidimensional and complex problem, all those things, if prosecuted more aggressively, might produce some results. So there is, I think, underway, as you've heard from the discussions by various officials from the Federal Reserve, from the Secretary, from other parts of the policymaking community, there are efforts to to accelerate that process, because not to do that does run some of the risks that you just talked about.
Any other observations? No. Okay. Any other questions? To you, Matt.
So this question is actually for Art. You mentioned that in the kind of the winding down of the SIFIs, that one of the goals is to kind of maintain priority of the creditors. What happens when you come across claims, though, that are kind of more systemically risky than others? You know, things like short-term lending, which may be unsecured and at the bottom of the barrel, but on the other hand, by, you know, imposing losses on them, you risk the probability of a run elsewhere in the system. How do you, what's your thinking on that trade-off?
Right. Well, again, to be clear, we don't have, there's no fund there to provide protection. There's no external fund. So all we have are the resources of the estate that are available. But there have been instances where what we've done with banks, so if there, for example, were some short-term creditors who were important to the firm, and if we were doing a resolution where, say, we were selling it to an acquirer, potential acquirer, and if this were viewed as an important funding source, it could be the case that we bid it out both ways. The acquirer can take it with assuming these short-term liabilities or without, and we've done this with banks with respect to insured deposit, with respect to uninsured deposits, and that's what we do when a bank fails. We have the acquirers bid both assuming the uninsured deposits and without assuming them, and in many instances, the bid that assumes the uninsured depositors, in effect, the acquirer takes those losses rather than the FDIC, is the better bid. So we would probably do something like that. We do not have the ability to make an exception for these short-term creditors, but it could be possible that there could be, it could be that as long as we provide the other creditors in the estate with what they would receive under bankruptcy, there may be some ability then to construct a resolution where certain creditors are taken care of. However, we put out a rule saying that we should not expect that to be the case. So, this is one of the difficult areas of this resolution authority, and we're going to use some of the methods that we've used in the past, but this is where we are. You know, this is not intended to be a bailout mechanism, and so if there are losses to be taken, there are losses to be taken, and you know, we hope that by the planning ahead of time that we can minimize the implications of those actions. But if creditors have to take losses, they're going to have to take losses, and the market has to be prepared for that. And so that's where we are.
Could I just add to that? You know, I think what Art said is really important, the last statement, because in addition to Art being in the resolution business, we're also all of us are in the prevention business. And there are two aspects to that I think are important. One is the fact that that Art and his colleagues now have orderly liquidation authority is something, and that they're requiring living wills, and the fact that the Fed is going to be subjecting a lot more institutions to heightened prudential standards is something that will impose discipline on their activities. And the things that our colleagues from the CFTC and the SEC are doing, and that we're trying to collaborate with, ought to do the same thing. So if we can impose more discipline on financial activities, then that works towards preventing the buildup of imbalances that you know, got us to where we were in the past. So there's nothing wrong with taking, managing, pricing risk. That's what financial institutions are supposed to do. But the question is whether that risk is mispriced and whether the markets, as Charles alluded to, and others have alluded to, are transparent or opaque. And our premise is that increasing transparency will promote more market discipline and more appropriate risk-taking.
I'd add that, of course, creating, so to speak, a map of exposures between institutions is so that we do have a better understanding of how much contagion might be associated with requiring creditors to take losses is something that's very much a part of the DoddFrank program and is something which we'll probably get better at over time, but we should have more up-to-date and more complete information on just how much contagion risk there is. And that, I think, will help very much in both addressing the moral hazard and thinking carefully about the systemic implications. But quick follow-up, Matt, is there?
My worry was less about the institution that is being unwound, say like Lehman. It's more about the collateral damage on other institutions like Morgan Stanley or Goldman or whoever, who might have a similar funding policy, which also may be a problem in itself, but they're, there's no mechanism to protect them, even though they're not, literally at risk at that point.
Right. Alan.
Thanks, Charles. Alan Mendelowitz. The worst kept secret in Washington is how bad data is in the financial sector and financial firms. And it's one of the reasons why DoddFrank placed so much emphasis on fixing the data. And as Andrei pointed out, it's a once-in-a-lifetime opportunity to fix a major problem. It's critical for the ability of the financial sector to manage itself well, and it's critical for policymakers and regulators to be able to do a decent job doing what they're required to do. Yet, the panelists have indicated how they, in effect, have handed over the mandates in DoddFrank to the private sector to implement. The mandates are not on the private sector. The mandates are on the government. Now, there are obviously good reasons why you want to have very heavy industry involvement. But when you hand something over completely, you have to have a way of staying on top of it to make sure that you don't get suboptimal outcomes. So I'd be interested in getting some insight into how the panelists see their monitoring of what's going on and fulfilling their mandates that have been handed to the private sector and making sure you don't get suboptimal solutions. And I'm going to give you one example of what I'm talking about. The LEI effort that's currently underway is the major way of fulfilling the OFR's responsibility to create a financial company or counterparty reference database. They're off to a good start, and they're doing all sorts of things. But it's clear at this point, though, there are inconsistencies built into what they're doing. For example, the same financial firm will be defined within the LEI with a unique identifier if it's a counterparty to a transaction. Yet that same firm, if it's represented in the transaction as an underlying, is going to have an entirely different identifier. Now, there may be a good reason for this, but it seems pretty inconsistent to me. And a good system, or the best system, I think, should have a firm referred to with the same identifier, if it's there, whether it happens to be a counterparty or the underlying to the transaction.
Thanks, yes. Dick.
So, Alan, thanks for your question. Let me be clear on what the LEI really is. By its name and by construction, it's an effort to precisely identify legal entities and to be able to specify a hierarchy that aggregates up into firms. So if we take some large, complex financial institutions that my colleagues have talked about, some of those firms, as you know, have hundreds of legal entities within them. And the basic point here is that by identifying transactions of a legal entity we can then aggregate up into the business unit and then into the firm level transaction. So it seems to me that there's nothing inconsistent in the way that we're trying to prosecute the LEI system. In fact, it enables risk managers, it enables business unit heads in the firms because they're developing similar systems for their own MIS and their own risk management, their own internal reporting, to do that aggregation and those hierarchies within the firm to get to the enterprise level. And the fact is that, you know, as you know, when we talk about risk, there's net risk and there's gross risk. And those two things can be very different. Netting out can be interesting in looking at risk, but if we want to know whether a firm is bought protection or sold protection, as Craig was discussing, sometimes those things don't net out. And it's much more useful to think about risk management to look at the gross risk. And even in the thinking about gross risk, it's the terms and conditions of that risk that a particular entity has engaged in that you know, may differ. So it's not just the exposure, it's the kind of exposure that's involved that we need to go beyond the LEI, which simply identifies the entity involved, and then think about the terms and conditions of the risk that was taken. We have to start with the first steps to standardize the data. Then we move on to the more sophisticated identification of risk that the risk managers are charged with performing at the firm level. And I just, you know, say, as far as the mandate is concerned, we embrace and take on the mandate that was required by the statute. But what we are doing is not to hand it off to the private sector, but to ask the private sector to develop the solution while we maintain the governance around the LEI.
We're out of time, unfortunately. I hope you feel, as I did, that the panel gave you a fascinating look at what is going on, and you feel as frustrated as I did that we didn't have a longer chance to cross-question them. But that's probably the best time to stop when you're still finding it very interesting. Let's thank them all. Thank you.
Thank you.